everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this Courthouse Steps oral argument on the case Diamond Alternative Energy versus the Environmental Protection Agency. Speaking with us today, we have Mark Pinkert, who is a litigation and appellate partner at Holtzman Vogel, and we're thankful to Mo Jaziel for moderating this Courthouse Steps program today. He is also a partner at Holtzman Vogel and has a broad litigation practice, including experience in matters from constitutional cases to white-collar crime to environmental disputes. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. And during the program, we may turn to the audience for questions, so if you have a question, you can enter it into the Q&A function at the bottom of the Zoom window, and we'll do our best to answer as many as we can. And finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Mo, thanks so much for joining us today, and I'll hand things over to you.
Great. Thank you, Edith. And Mark, let's show the world how smart you are. And let's start with a pretty basic question about Diamond Alternative Energy versus EPA. Can you give us a bit of background on the case, what it's about, and what the issue was before the United States Supreme Court?
Sure, absolutely. So the issue in this case is Article 3 standing, and it's specifically about the third prong of the well-known Lujan test. So it's about redressability, or in other words, whether a court order or judgment in a case will actually redress the injury that the plaintiff suffered. But the case comes out of a challenge to a 2022 EPA rule under the Clean Air Act. It's sort of a long and complicated procedural history. I'll go into it a little bit. Mo, if something's not clear, stop me, or if I'm going on too long, use your prerogative as moderator to just shut me up. But
Sure.
So let me go back to the beginning with the Clean Air Act. The Clean Air Act gives the Environmental Protection Agency the authority to regulate emissions from new motor vehicles. And in doing that, it also preempts state emission standards. And there's sort of an obvious reason for that, which is, car manufacturers mass produce vehicles. If they had to navigate a patchwork of 50 state emission standards, it'd be sort of impossible to do. So the Clean Air Act preempts state law on new vehicle emissions. But there is one exception to the preemption provision, which is the EPA can grant a waiver to the state of California, and California alone. It's the only state that can seek a waiver to allow it to enact its own emission standards. More recently, the Clean Air Act was amended so that now other states can follow California's standards, but only California can seek a waiver. So after the Clean Air Act was enacted in the 60s, EPA granted several waivers to California, really to deal with sort of local smog issues, things like in LA, how the pollution can get. And it got several waivers to deal with that and to enact its own emission standards for those purposes. But more recently, California wanted to be at the forefront of climate change policy. And so it started enacting more aggressive emission standards for new vehicles. At first, the Bush Environmental Protection Agency under George Bush rejected the waiver application as sort of not localized and not specific to California. In 2012, the Obama EPA does grant a waiver to California for its very sweeping emission standards. Essentially, what California had done was required auto manufacturers to reduce emissions in their fleet by producing more electric vehicles and using emissions reducing technology. And also, car companies actually had to specifically increase the percentage of electric vehicles in their fleet. So in 2013, the EPA grants the waiver, concluding that it satisfies the statutory requirements. In 2019, President Trump, his EPA rescinds the waiver, basically finding that climate change is not a California-specific issue. Now, again, there's another back and forth. In 2022, under Biden, the EPA reinstates the waiver, finding that climate change is a compelling and extraordinary condition under the statute. So there's this ping-ponging back and forth between administrations. But it's the 2022 waiver under President Biden that prompts this case. So the petitioners are various entities within the production and distribution stream of liquid fuels, produce gas, diesel, biodiesel, ethanol, things like that, and various trade associations. And they challenge the EPA's waiver. They petitioned directly in the DC Circuit which actually doesn't reach the merits of their claim and holds that these fuel companies lack Article 3 standing. And the reason is, well, the DC Circuit assumes that there's injury. The fuel producers can sell less fuel because there are less fuel ingesting cars on the road, and that is caused by the waiver, the EPA regulation. But the court held that there was no redressability on the third prong, and the reason essentially was that in their view, the petitioners did not put on sufficient evidence to show how car manufacturers would react if the waiver was set aside by the court. There were sort of two reasons for that. One is that since the 2013 waiver under the Obama administration, car manufacturers had invested substantially to make electric vehicles. So they built out their production lines for that purpose. They had also generated consumer demand. And so, according to the court, it's not clear, or at least disputed, that automakers would sort of go back to producing more fuel ingesting vehicles when they had already made the substantial investment in electric vehicles. And second, the DC Circuit concluded that the Biden waiver of 2022 was going to sunset in 2025. And because of that, the DC Circuit said, well, not only do car manufacturers have to change their behavior, but they're going to have to do that in only 3 years. So they're going to have to completely change their production lines just within 3 years. That makes it even less likely. And so there's no redressability here. At least the petitioners failed to establish it. The petitioners file a cert petition in the Supreme Court on both the Article 3 standing question and on the merits of the waiver. The Supreme Court only takes up the Article 3 question. And so that's where we are now. And the question presented to the court, and there was an oral argument yesterday, which is, when can a non-regulated entity, because in this case, the fuel producers are not directly regulated by the emission standards, but when can an entity who's not directly regulated establish redressability based on the future actions of a regulated third party? So it's a very long background introduction, but that gets us, I think, to oral argument.
Yeah, I think that's helpful for the folks. And I'd like to underscore a few things that are going to be important as we keep having our conversation. Number one, it was the fuel producers who petitioned. It was not the car manufacturers. The car manufacturers are the ones who are actually directly regulated through this waiver process, which is unique to California. Also, because this was an agency action and it was a petition for review filed in the DC Circuit, which is how the Clean Air Act tends to work, there's no trial. We have an agency action, and we're talking about Article 3 standing that applies across the board in all federal litigation, but we're talking about it in the context of an agency action. I think that'll be important as we continue our conversation. So, court grants cert, Mark. Court hears oral argument. You listen to the oral argument. Can you just highlight for us the key arguments from both sides, the petitioners and the respondents?
Sure. So the petitioners make two primary arguments. The first is that there's a categorical rule that if the government enacts a regulation that hinders a party's ability to sell something into the market, there's some hurdle that affects third parties from selling their product, that necessarily the removal of that hurdle will redress their injury. So there's really not an evidentiary burden. It's just sort of a common sense categorical rule. The rule harmed us. If you remove it, we're redressed. The second argument is a more sort of fact-specific inquiry. And what they said here is, under another line of the court's cases, like the Department of Commerce cases from a few years ago, in this instance, a party has to show the predictable effects of the third party's action. And here, the petitioners, the fuel producers, say it's pretty predictable that the car manufacturers are going to start producing more fuel ingesting cars if the waiver is rescinded. They rely on sort of basic economics, common sense. This is not one of these cases where there's sort of a long chain of events and there's a lot of speculation and attenuation. It's just sort of basic economics that if you remove an impediment to certain conduct, these automakers are going to engage in it. And relatedly, they say, look, it's not a high evidentiary burden. We put on enough evidence in the DC Circuit, and we could talk a little bit about this later. As you said, there's something odd there that this is a petition directly in the DC Circuit. So there's no 12B1 evidentiary hearing. They submitted declarations along with their brief. And so the question is, how does the court kind of procedurally deal with that? But that's essentially the fuel producers' arguments. Two other points about their arguments. So those are the two overarching points they make. The petitioners also point out that the DC Circuit's analysis was wrong for two reasons. One, that it just adopted too high of an evidentiary standard for proof of redressability. They don't really need to prove definitively what's going to happen in the future, that it's a more relaxed standard. But second, and this is a factual point, that the DC Circuit understood that the Biden waiver would sunset by 2025. And that factored heavily into the DC Circuit's analysis. It said, look, and I said this earlier, the DC Circuit said, look, the car manufacturers, not only are they not likely to change their behavior, but they're not going to, gear up and start changing their entire production line only in 3 years before the waiver sunsets. But that was actually a mistake. And in fact, all the parties have agreed now that the waiver was not intended to sunset, that it was supposed to continue in perpetuity. And so the petitioners point that out, and that was important at oral argument. The respondents, the government, the state of California and the federal government, their argument was essentially, look, it's always the petitioner's burden to establish standing. It's an evidentiary burden, and they just simply failed to do that, especially in a case where it's actually not common sense. It's not clear how the car manufacturers are going to respond, given that they have invested so much in their electric vehicle lines. They've created consumer demand. Everyone wants Tesla. Well, maybe not anymore, but people wanted Teslas for a long time. And so there was consumer demand, and it's not clear that car manufacturers would sort of go back in time. And so where there's sort of a dispute or a lack of clarity, it's on the petitioner to come forward with evidence. And they also obviously challenged the categorical rule, and in their view, the court's precedent doesn't really support that categorical rule that the petitioners articulated.
So, Mark, before we move on to what the justices were thinking and saying out loud, in your review of the briefing and in your review of the oral argument presentation from the petitioners, I'd like to ask you how the petitioners dealt with the FDA versus Alliance for Hippocratic Medicine case, where the doctor's theory was, the court said, based on speculation about increased patients from certain medication. How is it that the petitioners dealt with that particular case in arguing that, hey, this is common sense, basic economics? What material, what arguments did they put forward, kind of distinguishing their position from the Alliance for Hippocratic Medicine?
Yeah, no, it's a good question. So they really dealt with it, I think, in two ways in their briefing and at argument. The first is they distinguished the case. In that case, which dealt with the abortion drug mifepristone, the doctors who had a sort of moral objection to abortion, one of their arguments for standing was there will be women who take this drug will suffer from consequences or will suffer they'll have complications with the medication. They'll have to come see us, and that sort of puts us at risk of malpractice claims. So it's a much more attenuated type of chain of events that I think the Alliance for Hippocratic Medicine addressed. So the petitioners factually distinguished this case, which is really just, we want to sell fuel into the market. There's a hurdle to doing that. If it's removed, we'll get to do it. The government has sort of tilted the market away from us. We just want you to tilt it back so we can compete in that market. And I think it's pretty compelling to me that distinction. They also seized on a line from that decision, which said there are certain categories of cases where you don't need a very sort of high evidentiary showing, and that it's more, you can rely on inferences and common sense. So the court in the Hippocratic medicine case sort of recognized that when you don't have that chain of attenuated chain of events, that there are certain categories of cases where it's just a lower standard and just sort of more obvious on the face of things. And in the petitioner's view, that's this case.
Okay, so now let's fast forward to, your impression of the justices and how it is they perceive some of these arguments and whether or not they're open to the categorical rule versus the more fact-based evidentiary presentation rule. So let's let's start there. Do you think the petitioners are going to win on either theory of the case?
I do. I think I don't like to make predictions. I'm not very good at it usually, but I feel very confident that the petitioners are going to win. I actually think this may be an 8-1 or 9-0 case in their favor. That said, I don't think they're going to have the court, I don't think will articulate the categorical rule. Several of the justices sort of questioned the need to do that in this case, given the evidentiary record. They questioned sort of what the boundaries were and how clear the categorical rule is. And several of the justices said, straight up, I mean, Justice Kagan said, basically, I think on the evidence here, you've won. So she really, I think, tipped her hand. Justice Sotomayor seemed skeptical of the petitioner's arguments at first, but she said, the evidence sort of tilts in your favor as well. So I think what's going to happen here is you're going to get a lopsided opinion in favor of the petitioners on the narrow evidentiary path. That said, I do think Justice Kavanaugh, he actually seemed to prefer the broad rule, and that's in part because he articulated that exact rule in a DC Circuit opinion from 2015 in a case called Energy Futures Coalition. And that was a case the petitioners relied on in the DC Circuit. And he basically said in that case, I mean, very simply, if the government prohibits Company A from using Company B's product, which is essentially what's happening here, Company B has standing to sue. So I think you might see a concurrence from him going for sort of the categorical rule. But other than that, I think the court is leaning heavily in favor of petitioners on a narrow rule. And there are, like I said, I don't like to predict based on oral arguments, and the justices don't always tip their hand that often. But in this case, there were 3 or 4 questions that I think really just ended the case. I mean, frankly, I think that it sort of with the nail in the coffin. The first is that, so both Justice Kagan and Justice Thomas put the attorneys for the government in, I say, a catch-22 that they frankly could not get out of, which is the argument for no standing is that the waiver is not changing the behavior of car manufacturers. In other words, if the waiver is rescinded, car manufacturers are still going to produce EVs at a rate higher than California's standard. So that would sort of win the case for them, if true, on standing. But the problem with that is it essentially means that the rule is unnecessary, which means it's arbitrary and capricious. There's no basis in the statute if California can't show an extraordinary and compelling circumstance if the waiver has no effect. And so Justice Kagan posed this question to the Solicitor General from California, and Mo, I consider myself to be an educated man. I did not understand his answer to that question. There was really it was very hard to decipher, and I think that was pretty dispositive there. Justice Kagan also pointed out that California submitted a declaration in the case when they sought to intervene, which said pretty straight up that we need this rule because if we don't have the waiver, there's going to be more fuel emissions, more greenhouse gas emissions. I think that's pretty much a concession that removing the waiver would mean more consumption of fuel, which redresses the pocketbook injury that the fuel producers suffered. I think all the justices or many of the justices noted the DC Circuit's mistake on the sunset. So that, I think shows that there was sort of harmful error in the DC Circuit's analysis. And the last question that I think was really telling, Justice Alito asked Ed Needler from the Solicitor General's office, if just one car maker made one more non-electric vehicle, and there was just one more sale of 1 gallon of gas, shouldn't there be standing? And the government's response was, well, you need a material change to get redressability. And I don't think that is right at all. If you are injured by $100, you don't need to establish that you're going to get all $100 back. I think if you get $50 or 40 or 30, you have Article 3 standing. So I thought Justice Alito's question was sort of a nail in the coffin also, and the government's response was frankly not compelling. So those 4 questions I think were really dispositive in my opinion.
Yeah. And so Justice Jackson asked a question about gap in evidence, and that brings me to sort of a broader concern that I have with the case. Because this was a petition for review case, this wasn't one, as you pointed out, there was a 12B1 determination on whether or not they're standing at the pleading stage. And as we know, if this were a federal district court case, and this was not a case that was a challenge to agency action, so there's a very confined record. The burden on the petitioner is low at the pleading stage. It increases at the summary judgment stage, and it increases further at the trial stage. So the burden under Lujan continues to go up and up and up and up. Uh, how does one establish standing in a petition for review context? Is it just standing at the very beginning? How do you deal with contradictory evidence? What if the auto manufacturers had put in declarations of their own as interveners that were very forceful and made the point that, the petitioners are just wrong? In other words, if they'd set up a clash, how would the courts have dealt with this type of redressability problem in that circumstance, Mark?
No, I mean, I think you're exactly right. I think that's the huge wrinkle in the case. The court didn't really deal with it at oral argument, although you pointed out, Justice Jackson talked about the gap in evidence. And a lot of that was sort of, I don't want to say procedural maneuvering, but the goalposts, I think, sort of moved on the petitioners because they file their petition for review. They do append declarations, and they address standing to some extent. They append declarations to their opening brief. But they primarily relied on the Justice Kavanaugh decision from 2015. In the DC Circuit's local rules, you have to address standing in your opening brief, and they kind of did that. The EPA didn't even, in its response, didn't even challenge standing, which is odd because the EPA almost always does that. And then the California interveners challenged standing, and then so they tried to get in their reply brief a little bit. The petitioners did. Then after oral argument, they wanted to have they wanted to submit supplemental declarations, and the court didn't let them do that. So it is actually, I think, a little bit of a problem that the court needs to deal with for petitions for review in circuit courts. Like you said, the DC Circuit is not going to put up witnesses. They're not going to have an evidentiary hearing. So I do think that the way to deal with standing in these types of cases is you need some sort of categorical rules. You need some common sense understanding that you can determine standing from the face of the papers without live witness testimony and evidence, because it's not going to happen in the circuit court setting. So I do think that's a problem, and I think in instructing lower courts, I think the Supreme Court, in its opinion, ought to give some instructions to both district courts and to circuit courts on petitions for review.
Yeah. And so zooming out again a little bit, the court has been dealing with some pretty significant Article 3 standing cases lately: Spokeo, TransUnion, Biden versus Nebraska, Hippocratic Medicine, California versus Texas, Murphy versus Missouri. Mark, what trends are you seeing in this Article 3 area? First, let's talk about whether or not folks are applying sort of an originalist rubric to dealing with the issue, and then work us through what rubrics are actually being applied and what we can glean from them.
Yeah, no, it's a great point because I actually find the lack of originalism in this area actually very striking. This is known to be an originalist court, and so if you have a Second Amendment case or First Amendment or any other constitutional issues, you're going to make originalist arguments in your briefs, and it's going to come up at oral argument. There was in this area, it's gone essentially. There's no originalism. There was no discussion at OA about the original meaning of case or controversy in Article 3. Remember, standing is not a term in the Constitution. It arises out of the case or controversy terms, but there was no discussion of what those terms mean. There were almost no amicus briefs on original meaning. The Cato amicus brief pointed out that the court has strayed from originalism, but there was no amicus briefing on it. It was all about sort of prudentialism and dealing with the court's sort of judge-made doctrine. And I think, Justice Thomas made a run at this in his Spokeo concurrence, and then again in his TransUnion dissent. He has pushed for an originalist understanding of Article 3 that would have a much more capacious understanding of what a case is, really just a cause of action or interference with a private legal right. And then there were many circuit judges who were advocating for that view as well. On the 11th Circuit, Judge Jordan and Judge Newsom wrote really interesting originalist decisions on Article 3, Judge Thapar, Judge Wood on the 7th Circuit. So there was a little bit of a movement, and then TransUnion sort of cut it off. And it's just really interesting to me that that it's just not even an issue in these cases. Now, I think that without grounding in originalism, the trends are that you have these malleable judge-made standards, and that has really been the perennial criticism of the Article 3 standing doctrine, which is, you know, it's sort of very subjective. It can be used for sort of like, hot button political cases, and actually in recent cases, the justices have accused one another of manipulating the doctrine for to avoid deciding important cases um, uh, in the Murthy case, which was the social media case. Justice Alito had a pretty stinging dissent. In the Biden versus Nebraska student loans case, Justice Kagan really straight up accused Chief Justice Roberts of manipulating standing doctrine to reach this issue, which she thought there was no standing to reach. So the court's really struggling with that, and I think that is because they've gotten away from originalism, and they're having to grapple with these procedural aspects that you really intelligently pointed out, like how do you establish it, when, what evidence do you need, and then even substantively, what is an injury? What's an injury in fact? And that's my personal view is when you get away from originalist interpretation, you're going to have the sort of common lawmaking, and there's not a lot of consistency. Um, so I think that's sort of the trend I'm seeing. Look, the court has some legitimate concerns about opening the floodgates, to a ton of litigation where there are people not real interest in the case. So you look at TransUnion, that was on the Fair Credit Reporting Act, and the plaintiff class was complaining that there were letters sent that didn't have proper formatting, and so you're gonna have plaintiffs' lawyers going around suing left and right. And I sort of understand that concern, but in my view, that is an issue for Congress to narrow the causes of action, not for the court to sort of make up Article 3 judicial standards as they go. And just the last point on that, Mo, is that I think the overarching issue is not really a unifying theory of standing doctrine. You have the FICRA case, the TransUnion case, but then you have FOIA cases where there's right to information. You have First Amendment Establishment Clause cases where you have a sort of psychic injury. You have qui tam. You have so there's no really unifying theory of the court's Article 3 standing doctrine, and I think it's a little bit all over the place. And so my question going forward, I don't think this is going to be the case, but will Justice Thomas file a short concurrence here, putting that flag down again and hoping maybe he can peel off one of the 5 justices from the TransUnion majority and sort of shift this Article 3 mess back into a more clear and straightforward originalist doctrine.
Yeah, all good points. And just to underscore the concern from some of the regulated communities' perspective, right? These environmental statutes all have citizen supervisions. And if you have no limiting principle in the Constitution or in the statute, how do you keep the floodgates from opening up? But as you point out, that's frankly probably a concern for Congress. And if Congress wants to write citizen supervisions, they can. And
Yeah.
we must deal with the consequences if redressability is read broadly, injury is read broadly. So Mark, we've talked about Article 3 standing. We've talked about this case. We've talked about certain trends. We've talked about some concerns about how, you can apply a rule in a more fact-intensive scenario. With that entire background in place, do you expect this case to have some far-reaching consequences? Or do you see this case as being more limited when it comes out to sort of the administrative law context? What do you foresee the court doing? I'm sure Justice Gorsuch's silence will give you all the answers. So with that,
Yeah, that was interesting. He didn't say a word the entire oral argument, which was interesting, and he tends to be very engaged in administrative law cases. Um, because the court has constitutionalized these issues through its Article 3 standing doctrine, I do think it will have far-reaching impact. I don't think it needs to. I think the question in these types of cases is, well, if you have a cause of action, you have an Article 3 case. And so the question would be specific to any given statute. And here, the Clean Air Act judicial review provision is quite broad. And of course, like you said, if the floodgates open and if there's a ton of cases that are slowing the wheels of government, Congress can amend the statute to narrow the scope of potential petitioners. The APA, for example, you have to be aggrieved by final agency action. So, that's what I think these sort of standing questions should be specific to the given statutory cause of action. But because they're not, I do think this case will have some far-reaching results. I think if the court were to adopt the broad rule, and I don't think they will, but I do think that would have a pretty far-reaching effect on administrative law, because then you have a lot of third parties who can claim to be affected by a regulation who could then come to court and try to sue, and that would sort of gum up the works for the government. But even on the sort of narrow evidence-based approach, I do think it will be an important case, just like Murty, just like Alliance for Hippocratic Medicine, just like Department of Commerce, because the court is having to instruct lower courts on how to apply this sort of open-ended, loosey-goosey standing doctrine. And so every case is then becomes important in giving lower courts and litigants direction. And interestingly, the result of that is, because there's so many of these issues coming up, the Supreme Court is actually taking up a disproportionate number of standing cases every term. They're taking fewer and fewer cases overall, but they seem to be dealing with Article 3 standing all the time. And, that's sort of their own, problem that they've created for themselves. But that's, I think, the result is that every time there's an Article 3, there's some new issue, the unique sort of procedural history here. Now they have to deal with redressability. And how do you do that at the circuit level in a petition for review? So there's all kinds of things that they're going to have to clarify over and over again until they change course and go down Justice Thomas's road towards a more originalist understanding of standing.
So if I understand this right, Mark, what you're saying is the court's recent jurisprudence seems to be sort of a nip and tuck job on Article 3 standing issues as they arise. Whereas Justice Thomas, if the court were to go down that road, could give us this all-encompassing standing doctrine opinion for all time. But it has a potential to open up floodgates, and from a pragmatic perspective, it may not be the best possible thing short of some kind of congressional action. Is that fair summary there?
Absolutely. And I'll just add 2 points. One is Justice Thomas's view of standing, which he explained in Spokio and TransUnion in his concurrence and dissent in those cases. There would be some limit on the quote unquote floodgates, because in his view, there's a distinction between private rights and public rights. And so you mentioned earlier, the citizen suit provisions where a citizen can sue the government for, failing to follow the law or follow procedure. I think in his view, those rights inure to the public and are sort of like generalized, and therefore there is no case or controversy. Now, a lot of scholars disagree even with that, but under his sort of view of the originalist understanding of Article 3, I do think that there is some limiting principle to who can get in court under citizen suit provisions. And then, I think short of that, there is the nip and tuck and the incremental decisions. And then you get very frankly strange decisions like Murty v. Missouri. And I find it to be kind of a strange decision, because if you read it, the court is like painstakingly going through the record, analyzing the evidence, and making a determination as though they were the court of first review. And that is a little bit odd when the Supreme Court tends to announce broader legal rules. And so for them to have to go in every case and like analyze the record in painstaking detail is just not what they ought to be doing. And then, what happens is lower courts start to read those decisions like statutes, and you get these sort of interpretations of these decisions, and it can become a mess. So that's exactly how I see it, at least. I mean, it could be wrong, but that's my view of why the court ought to. I mean, there are lots of reasons why it should return to an originalist interpretation of Article 3, but I actually think that pragmatically it makes more sense for them.
And so, Mark, it's no secret that given the current climate, there are lots and lots of lawsuits against lots and lots of federal government action. Do you see this case having an effect on any other currently pending cases that perhaps are more top of mind in the public's attention?
Yeah, I mean, look, there are, I think, an unprecedented amount of cases against the Trump administration. They're kind of hard to keep track of. But I do think inevitably, when you're talking about standing for suits against the government, this decision will probably have a rippling effect through those cases. And just thinking broadly, and I can't think of any particular cases now, but a lot of the suits against the Trump administration are brought by individuals, states, advocacy groups who are actually not directly regulated by a particular executive order or agency action. They're sort of maybe affected more downstream. So I think in one of the USAID cases, there's an AIDS advocacy group that's suing, but the funding I don't believe would be going right to that advocacy group. So I think in those sorts of cases where their standing turns on the what happens to a directly regulated party, then yeah, certainly I think that this decision here could affect how those cases come out. A lot of those cases are already up on PIs and TROs and are moving pretty quickly. So it'll be interesting to see whether the federal government starts, relying on these sorts of standing arguments as those cases progress.
Sounds good. And we've got a couple of audience questions. I think we answered one of them already, but here's another. When do you think the court will reach a decision in this case?
Our argument was end of April. So I think towards the end of the term, they've been sort of drifting later and later into the summer. I would say by end of June or July, if I recall when, I would say around then.
Yeah, perhaps sooner. I don't think this will be the most
Yeah,
hot button
yeah,
case.
that's yeah, that's a good point. And I do think there's pretty widespread agreement on the court. So it should be a pretty straightforward decision. Like you said, Justice Jackson may be the only one that I sensed would vote for the respondents. But she even asked some questions that suggested. So if it's a 9-0 decision with some short concurrences from Thomas and Kavanaugh, then maybe, yeah, maybe it could be sooner. That's a good point.
And with all these Article 3 standing cases that have been at the United States Supreme Court, any particular lower court judges that you look to when it comes to Article 3 standing issues and seeing whether things can be fleshed out a little better? Because as we all know, lower courts do a tremendous job fleshing out some of the things the Supreme Court has left gaps in. And so, Mark, what are your thoughts? Who should people go to if they're trying to better understand Article 3 standing issues and folks who are fleshing out some of the details?
Well, let me just give a plug for Judge Burt Jordan, who I clerked for on the 11th Circuit. When I was clerking for him, he wrote an excellent dissent in a case called Moransky versus Godiva Chocolate that laid out the originalist argument for Article 3 standing. And he really goes through the history. And he actually also, what I think is great about that decision, or that it's actually dissent, his dissent, he actually squares the originalist understanding with some of the court's earlier precedent. So if you're interested in the originalist view of Article 3, you could look to his dissent there. Judge Newsom eventually, I think, who was not with him in the Moransky decision, eventually came along, and he's written some interesting concurrences and dissents. So that's on the 11th Circuit. I think Judge Thapar has had some interesting decisions on originalist views of Article 3 standing. Like I said, that movement kind of lost in the TransUnion case, but maybe it'll be resurrected at some point. But as far as fleshing out, yeah, that's a good question. I don't know. I'm sure there are a lot of great district court judges. I clerked for a great district court judge down here named Roy Altman. He fleshes out complicated issues, and he likes to bring the parties in and have them, have a chance to put on their evidence and always hear from both sides. And I think that's kind of one of the issues that we raised in this case, which is, when you're petitioning in a circuit, how do you have your day in court to bring your evidence in? You're not going to get to cross-examine declarants from the other side. So I'd be interested to see how the circuits, the DC Circuit, the Fifth Circuit has had a lot of petitions for review, although mostly during the Biden years. But I'd be interested to see how circuit panels deal with this decision.
Yeah, and if the audience can't tell, we're both 11th Circuit homers. So, with Judge Jordan, Judge Newsom, Judge Bill Pryor, I mean, these folks have written some pretty thoughtful opinions on Article 3 standing that are worth checking out. So, Mark, we've got a couple of other audience questions that have been trickling in, and audience, feel free to ask more. Here's a question from Tammy. Let's say you're right and there is a 8-1 decision. What is the likelihood of success for the plaintiffs back at the lower court level? Are there any implications for other lawsuits that are ongoing challenging California's standards?
So I frankly think that I think that the petitioners don't have a very good panel at the DC Circuit. They are all Democrat appointees. I think they probably, and not to say that they're political or anything, I just think they drew a bad panel for their particular position here on climate change. So if they go back down to the DC Circuit, I suspect that this case will be back up again. Although here's another point I should have mentioned earlier is that the Trump administration is currently considering the waiver and whether to rescind it again. So and I think it's very likely that that will happen and the case will become moot. And that came up at oral arguments that Justice Kagan asked the government, can you tell us what the Trump administration is going to do? And Ed Needler didn't want to say, but I think everyone sort of knew that what was coming. The government still defended the DC Circuit's decision because obviously they want to make it harder for petitioners to challenge their conduct, and they have a sort of vested interest in keeping plaintiffs out of court that are going to strike down their rules. But that said, I think the Trump administration is going to rescind the waiver, and maybe you have challenges from the other side, and we get a new challenge out of another court, and then we're back up. But here in this case, I think. Assuming that the case goes forward, I think the petitioners will have a tough time. They have a tough panel in the DC Circuit.
Yeah. I guess a cynic might say that the DC Circuit panel was trying to duck the merits by resolving this issue on standing, but that's the cynical approach because, frankly, third-party redressability is a serious question,
Yeah.
and it's worth exploration. So,
Although, can I just, I mean, one point, and this goes to what we've been talking about in terms of, the court having to nip and tuck and move incrementally. I never thought of redressability as that big of a deal, because if you have injury and causation, it feels like 99 times out of 100, if the defendant did something that caused you the injury and the court can then reverse that thing they did, it should be redressed. I usually don't see it as a sort of difficult. This is a unique case because this argument of how car manufacturers may act
mhm.
given their investment. But again, this is sort of, this is the problem with the judge-made law here is that creative arguments, new ways to get, to avoid the merits and to use standing doctrine to keep, hot button cases out of court. And I think this is an example of that.
Final question from the audience, if that's okay, Edith, is will congressional action with the upcoming CRA votes, Congressional Review Act votes, to overturn the EPA's waiver of California's EV mandates make this case moot if the Supreme Court sends it back to the DC Circuit after ruling on standing? So if Congress acts to take away uh, California's EV mandates, will this case on the merits just become moot?
Yeah, I guess that it would. And again, the other way to get there, I think, is the Trump EPA doing it by rulemaking, and they're currently considering it. So I think that that's right from the anonymous attendee. I think they're,
Very thoughtful questions,
yeah.
though anonymous. Uh, well, that's all we've got for the panel. It's at 45 minutes. Mark, you proved yourself to be just as smart as I said you'd be. So, you've proven me right. So thank you for that.
Appreciate that, Mo. Thank you for moderating.
Yeah, and on behalf of the Federalist Society, thanks to both of you, Mark and Mo, for speaking with us today. We're very grateful for your time and expertise. And thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and other upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.